Good morning, everyone. My name is Victor King. I'm chair of the California Law Revision Commission. Welcome to our first ever Zoom meeting. Please bear with us as we try to work with this new technology. It is being recorded, and all the commissioners except for one are present. We're going to dispense with the roll call because everyone's name is already displayed. So moving to the first agenda item, number one, we'll be discussing the minutes of the January 30 meeting, and that's your memorandum numbers 2020-9 and the supplemental.
Yes, and that's my memo, and the supplement sets out a couple of technical corrections. We noticed some cut and paste error in the original document, so it would be the staff's recommendation that you approve the minutes with those changes. And if you have any other changes you want to make, you'd need to discuss them now.
Okay, anyone have any changes or comments on the minutes? Okay, seeing none. Person second.
Oh, excuse me. I was not attending that meeting. Shall I recuse myself from voting?
You can just abstain.
Yeah, oftentimes people abstain.
And I'll do the same.
Okay, can I have a first and second for passing the meeting?
I'll move approval.
I second.
As amended?
As amended.
As amended, and bear in mind the amendment is in the supplemental memo. There's just some typos in the original memo. Okay, with it first and seconded, all in favor say aye. Aye.
Aye.
All say nays. Any? No. Extensions. And we have two.
Okay, so the abstentions were Diane and Richard Rubin. Okay,
very good. Now,
aye. Okay.
We're moving on to administrative matters, and let me preface this to the audience members by saying we will try on the substantive matters later in the agenda to ask that anyone who knows they want to be heard to signal by using the raise hand function on the Zoom software. And that way we'll be able to have a head count or an understanding of how much time we'll need to devote to that. If at any time a member of the public wants to chime in, of course, just go ahead and use the raise hand signal, even if you hadn't identified yourself at the beginning, and we'll try to squeeze people in as best they can. So moving on to the second item, the report of the Executive Director, Brian.
Yes, thank you. Well, obviously, things are kind of irregular. This is our first Zoom meeting. That we had a successful Zoom meeting for the Commission's other deliberative body, the Committee on Revision of the Penal Code. It went well, but the format is a bit bulky. And so I would say that we ought to do our best to be patient and take time for process. And, you know, it's going to be kind of awkward to be repeatedly asking if anybody wants to speak or that kind of thing, but I think that that's the best way of assuring that we go smoothly and everybody gets to be heard. I will run through a few things. I see that we've got some participants. We've got 8 people in the audience. Welcome, everyone. And when it's time that you would like to be heard by the Commission, as the chair said, just raise your hand. You can do that by clicking the hand raising button that should be visible on your interface somewhere. Do commissioners see that at the bottom of the screen? I see some yeses, some nos.
I don't act. Oh, there we go.
Okay. So some people have it. All right, well, we will have to see what happens when we get to the point where we call on people from the public.
Brian,
yeah.
if they don't see it, there's a button that says more. If they press on that button, then it will usually pop up on it and give you that function.
Thank you. People, it doesn't look like anyone's calling in from a telephone, but we should keep an eye on that because there's a different process that you use to raise your hand when you're on the phone. We are intending to take breaks, most notably a lunch break of about 30 minutes and when we get to a good breaking point sometime around noon. But at the meeting, the committee meeting, we took about 5-minute breaks about every hour. And I don't know that we want to institutionalize that, but I think commissioners should feel free to suggest breaks if they feel like it's time to just sort of clear your head for a few minutes. I think that this format is a little taxing, and so it might be nice to just be able to step away from it a couple of times. So that option exists. As the chair said, we're recording, and the meeting, once we're done, will be uploaded to our YouTube page. So this is all a permanent record. Does anyone have any questions about the format? Okay. The other item that I wanted to talk about was the governor's May revise of the state budget. You know, I'm sure you all heard there's a significant shortfall and pretty serious steps being taken to make up for that. The commission was not singled out for special treatment in the budget, so we're subject to the same general across the board measures as any other agency, I assume. And that means two things. One is the governor's going to be negotiating for 10% salary reductions for staff. You know, that's painful, but from the point of view of the agency, it's better than furloughs. It's better than a general cut that would require layoffs. It means that people are going to stay in their jobs rather than losing their jobs and going on unemployment, and we'll continue to be able to do our work. We're recruiting an attorney for the Committee on Penal Code Revision, and I wasn't sure whether we were going to be able to proceed with that until I saw what was in the revise and that it was a salary cut rather than a flat percentage cut. So we are proceeding with that hiring. Person will be walking into a job with a lower salary than they might have expected, but at least the job will exist. The other thing that we're supposed to do is 5% agency budget cut through efficiencies. And the guidance that I've gotten from the governor's office that was sent out to all agencies is that we're supposed to be looking at ways in which the unfortunate consequences of working at home might have a silver lining. So for example, we're not paying for any travel for this meeting. Also all my staff is working from home. So we were encouraged to look at ways to reduce facilities costs on the assumption that working from home would continue. And so we're going to be looking at the possibility of closing the Palo Alto office finally. It's, you know, it's not desirable to be working from home rather than together, but it's tolerable, and to the extent it can save us money, that makes sense. So I think that we can weather those cuts without a significant hit in terms of productivity. So I think that's good news despite the bad news. Does any commissioner have any questions about that? Okay, that's all I had for the executive director's report.
Very good. Thank you, Brian. Turning to the next item, commissioner suggestions. This is the part of the meeting where commissioners can bring up proposals for new study topics, discussion of our commission procedures, or other general matters not affecting any specific agenda item. Do I have any takers from the commissioners? Yes, Richard.
Thank you, Mr. Chair and Brian. It would be helpful to have some clarification of the type of recommendations, if many are to be made, with regard to potential legislation. I know there are limitations on what we're able to talk about in the sense that we don't have latitude to comment on legislation which is already in process that we have not already perhaps previously looked at as potential study items. So I guess what I would like to know, and maybe other commissioners would as well, is what suggestions, what are the boundaries under which we operate, whereby we can make suggestions if they are appropriate for new proposals for new study topics?
I think that there aren't many limits on what you can suggest. You aren't bound to suggest things that we currently have authority to study, because the commission can always request expanded authority if it wants to work on something that isn't currently authorized, and we do that. That's routine. I think the limitation, and this is something that I want to talk about when we get to the pandemic-related reform item. The limitation would be whether suggesting or commenting on a particular kind of reform would step on pending legislation in some way that would be inappropriate. And like I said, I'm going to get to that when we talk about the pandemic-related options. So I'd rather wait and answer that in that context, if that's okay.
That's fine. Would it be appropriate then to make some suggestions that I had in mind when you get to that item?
Yes.
Thank you.
Very good. Any other commissioner suggestions or comments? All right. If there's no objection, we're going to move the next memo to later to take place after the legislative program report for the interests of saving time, because I know one commissioner may have to leave early. So let's move directly to the pandemic response possible action, Memorandum 2020-19, and the supplement, the first and second supplement.
Thank you. That's also mine. And I suspect that's what some of the people in the audience are interested in commenting on. I recognize a couple of names there from people who've been communicating with me informally about it.
And if you know you will be commenting, you can go ahead and signal by using the raise hand function. Then we can keep track of who we will call upon.
Okay, good. I see a hand. I see 3 hands. So that reassures me that the system's working. So thank you. Just leave those hands up. We'll get to you. I think there's some general table setting worth doing before we get to the point of specific suggestions from the public. So the general thrust of this memo was to raise the possibility of the commission using some of its resources to do sort of emergency reforms to address the pandemic. The initial concept was that it would be most effective for the commission to do work that is sort of in our wheelhouse. So it's something we're already fairly familiar with. That's fairly uncontroversial, so that it has a reasonably good chance of enactment, so we don't waste our time on something that's pie in the sky. And that nobody else is likely to be working on, so that we don't wind up duplicating others' efforts. So that was the original concept. Some examples were given in the memo of things that might or might not fall into those criteria. And after discussing this with the chair, I skipped ahead on something that I had suggested in the memo, and I went ahead and sent the memo to everyone on our mailing list, all of our mailing lists, just in case people out there had ideas they wanted to share with us or weigh in on the general prospect. So in order to sort of compartmentalize the discussion, I think I'd like to start by just asking about whether the commission is interested in doing this, because if you're not, then we don't have to get into the details, and if you are, then we can move on. I'm seeing a couple of thumbs up. If you want to use there you go. Anybody have concerns about this? Because I'm seeing a lot of positive reaction. Okay. All right, that's helpful, thank you. Now, there's some scope questions that I'd like to discuss. One is whether to limit this work to the current emergency. Some of the materials that are in the memo are drafted with a sort of a triggering condition that conditions the operation of a proposed law on the existence of declared infectious disease emergency or something, whatever the magic words would be. I've seen, there's a bill pending that I'll talk about in a little bit on remote notarization that actually limits the effect of the law to the current infectious disease emergency. So it wouldn't persist beyond COVID-19. We got suggestions from some members of the public that we ought to consider expanding it not just to infectious diseases, but to any kind of emergency in California. And the good example that was given was like the wildfires. You know, we've had some really severe wildfire events that have disrupted the state and shut down areas. And it might be that, you know, a homeowners association in Butte County couldn't hold meetings that they needed to hold because the area was closed or destroyed. And it would be helpful to them to be able to do remote meetings. And so it's, I found that convincing that there's a need for that kind of work. I think the only counter argument is that it might be overreaching, that the legislature might be interested in quick solutions on the immediate problem, but less interested in urgency with respect to broader problems.
Commissioner Boyer-Vine.
Yeah.
So if you were to tag it to one of the emergency orders that come out, the confusing thing is, and rightfully so, because there's police power, obviously at the state and local level for public health. But would you tag it just to state emergency orders under the governor's authority, or would you actually look to tag it to county orders, of which there are a myriad of them right now that are confusing and garbled? Have you given that any thought?
I have, but I think I see that Commissioner Chow looks like he wants to say something.
Yeah, I just want to follow up on what Diane just said. I think there's a bunch of legislation out there that are tied to the pandemic, one of which I can think of is AB 828, which basically is triggered by the pandemic, in fact, on evictions. So it essentially places a moratorium on the filing of foreclosure actions as well as eviction. Also prohibits the recording of any NODs, notice of default, notice of sale, and the like. Now that legislation is set to sunset, in fact, to be repealed in 3 years, but yet it is only effective during the pendency of the state emergency. So it specifically spells out the date of the emergency was declared, and then it will probably end automatically when the emergency is lifted. So that's one of the legislation that's pending. That's AB 828. It's a get and amend, and it's by Assembly Member Tang, I believe, just for the reference of the commission.
Thank you. And to answer to Commissioner Boyer-Vine, I have thought about the question. I think it would require some care and careful thought that I haven't yet given it. But I think that before I do that, I'd like to just get some guidance on whether commissioners would be interested in looking beyond COVID, beyond infectious disease quarantine to any kind of emergency.
Well, I'm sorry, Commissioner.
Go ahead.
I mean, I certainly think, I understand why AB 828 is out there in the eviction issue under the governor's shelter-in-place order and his various executive orders, just looking at this pandemic. But I think that to just look at this pandemic would be short-sighted, and for this commission, I think that this isn't going to be the last pandemic we have, and I mean, you know, I'm chairing that study committee. I mean, we're certainly not focusing on this pandemic. We're looking beyond that. I don't even think this pandemic, the legal issues that are just going a mile a minute in the courts will be resolved in order to look at things very seriously in the short term. That's my point of view.
Commissioner Carrillo.
Yeah, I like the idea of moving forward with what I would call a set of tools that an executive authority, either at the state or the county level, could include in an emergency order. So not every emergency is necessarily going to rule out in-person contact, but if it does, it makes sense to have, kind of a ready-made slate of procedures, sort of like a smaller version of the Emergency Services Act itself, so that if, for whatever reason, the executive authority decides that as part of the emergency order, they need to invoke exemptions for in-person contact, then there's a set of procedures that are available that can be invoked simply by including them by reference in the order.
Commissioner Rubin, then Boyer-Vine. Commissioner Rubin?
There's a great deal of uncertainty about how long this pandemic is even going to last. And there's a great likelihood it will extend potentially beyond this year, or some of the implications of it will continue well beyond this year. We have no knowledge yet, scientifically or otherwise, what that portends, which means that any of the laws that are now being promulgated and to be ultimately adopted are likely to have to cover an emergency that has been extended well beyond the moment we're living in. So with that in mind, I think we have to be thoughtful of what, going along with what was previously said by Commissioner Boyer-Vine, that we want to examine and look at the possibility of legislation that's going to have coverage beyond the immediate moment, with a very strong possibility that it'll have to be invoked at a later period of time, and that could extend again, as I said, into a later year or beyond.
Commissioner Boyer-Vine.
So in answer to the tools in the toolbox approach, that's what my study committee for the Uniform Law Commission is focusing on. We're looking at what all the states have out there in terms of beyond isolation and quarantine authority or general authority. We're looking at collective purchasing mechanisms. We're looking at crisis standards of care for doctors. And so with a lot of really people much smarter than I am, because I know nothing about public health law, I would just wonder, whether that type of work is really within the ambit of this commission, or you'd have to go get additional authority, because it doesn't fall within the types of things like, notaries or the traditional work that the CLRC does. Brian, you have any thoughts on that?
Well, that's one of the questions I wanted to ask in this discussion. Is I agree with you that I think much of that would be beyond our existing authority. And the question would be, do we ask for greater authority, or do we just work in our existing grooves? Before we move on to that, I wanted to see if there was anyone who had concerns or objections about looking beyond the current emergency or infectious disease emergencies, and instead looking more broadly at any kind of emergency and how it could be accommodated. Okay.
Any objections, commissioners?
The Chairman King, at some point we have to figure out how to integrate public comment into this. From the tenor of the comment that I've received informally, I don't think anyone who's got their hand up would object to the decisions that the commission has made. But at some point it would be good to hear them and give them a chance to be heard. Do we want to
we can do that right now.
Okay.
Let me recognize in the order that they're displayed on my panel here, from the audience, John Anderson, if you have anything to add to this discussion, please.
So John, what I'm going to do, John, I'm going to toggle the button that allows you to talk, and you may need to unmute your mic yourself. There you go.
All right. Good morning, commissioners. Good morning, staff attorneys. Can you hear me?
Yes.
Okay, good. So just to remind you or let you know, I'm an estate planning attorney, and I am a member of the executive committee of the Trust and Estate section of the California Lawyers Association. So that is, I'm here primarily to speak to those subjects that are related to trust and estates issues. And there were a couple of a couple of things on in that regard. One is the possibility of having a remote online notarization of documents. That's something that TexCom itself has explored because other states during this crisis have enacted emergency measures authorizing remote notarization. We've made some efforts in that regard. Nothing has come to fruition yet, but we're still trying. As far as long-term changes, I would observe that the legislature has for 2 years running introduced an online notary act. I think the one that was introduced in 2020 was recently amended, so I think it's that one is not going forward. But I think there is momentum in that direction, and that we may ultimately see a formal online notarization process. In which case, we obviously wouldn't necessarily need something for just emergencies. The other estate planning related issue had to do with the remote attestation of wills. That is another subject that TexCom has considered recently in connection with AB 1667, which is the California Electronic Wills Act. As initially introduced, that act would have allowed, there would have been a mechanism for wills to be witnessed remotely over Zoom or a similar type of application. And our committee was opposed to those measures, and I think the Judicial Council agreed with us. So as that bill has been amended along the way, the issue of remote notarization has basically been taken off. I'm sorry, remote attestation has been taken off the table. As far as having some type of emergency provision for remote attestation, that's something the committee did discuss, especially in connection with this COVID-19 crisis. And the consensus of our group was that we have all in our practices found various workarounds that have enabled us to get through the process. For example, California, as you may know, allows for a handwritten will to be effective without witnesses. As well, California has what's called a harmless error rule, which says that even if a will is not witnessed, it can still be admissible as a will if it is demonstrated with clear and convincing evidence that it was intended to be the decedent's will. So some practitioners are simply attaching signing statements to wills saying this will was signed during the COVID-19 crisis, therefore it could not be properly witnessed, and relying on the harmless error rule to get the will in if necessary in the future. So I guess the consensus of our group was that we do not see a compelling need for a standby emergency remote attestation provision.
Okay, I'm going to take you offline again, John, so we can hear from the next person.
I'll recognize Valerie Cushall.
Before I turn Valerie's microphone on, I'd just like to comment that it's going to be difficult to sort of maintain our thread in this discussion if we're jumping between sort of the general questions and the specific examples and proposals that were discussed in the memo. So I believe that Ms. Cushall is probably interested in talking about notarization. I'll unmute her and ask for those who want to be recognized, if possible, you could limit your comments to the general issues that we've been discussing about whether the commission should do this, whether it should be limited to the present emergency, whether the commission should have expanded authority, that kind of thing. And then once we get into the specific proposals, we can again see who wants to comment on those. So having made that little speech, Valerie has lowered her hand, so that works too. Do you want to go to Ron Kelly?
Yeah, I'll go to Ron Kelly, but let me also add, Mr. Anderson, if you're finished for the time being, you can unraise your hand as well so that we could keep track. Thank you. I recognize audience member Ron Kelly.
Okay, Ron, you should be able to talk now. You're muted. There you go.
Good morning, commissioners. Can you hear me okay?
Yes.
Thank you. I'm, I guess you would call a political activist of long standing. I have followed the commission's work and sometimes actively participated in its studies over a period of maybe 20 years. And in response to your general mailing to the commission's mailing list, I simply wanted to say I think the commission is exactly the right place to take up this effort because of its history and its staff's skills in looking across all the multitude of codes that California has. And I simply want to encourage the commission to do that and to listen closely to staff's recommendations. That's the only comment I have. Thank you.
Thank you.
I think that looks like it's all the hands. Ron, if you want to lower your hand if you're done. I don't see any others right now. So maybe folks, raise your hand later if there's a specific point you want to comment on, and we'll watch for that. Thank you all. With that, I'd like to move on to the next general question, which is one that was previewed by Commissioner Boyer-Vine. It has to do with our authority. You know that we may not work on topics that have not been authorized by the legislature. We do have some general authority to study technical and minor substantive issues that's not limited to particular subject matter. But most of our authority is subject matter limited. And to some extent that makes sense if we're looking to work in the areas where we have a lot of subject matter familiarity already. But on the other hand, it might be constraining. And the example that I give, I think in the second supplement, is that one of the examples of possible reforms in the first memo was to basically mirror the governor's executive orders on teleconferencing and make teleconferencing available, notwithstanding other law or governing documents, to homeowners associations. And you know, that's a good example of something that's straight down the middle of our authority. It occurred to me when I was writing that memo that the same thing might be helpful to corporations generally, or any entity that's governed by the Corporations Code. If they've got bylaws that require an in-person vote or something like that, they might be hobbled right now. And it might be helpful to relieve them of that way, the same way that the governor relieved us of the constraints of Bagley-Keene so that we could be holding this meeting in this way right now. So it occurred to me not just that homeowners associations might benefit from it, but that corporations might benefit from it. And in thinking about the authority question, I realized that, I believe at one time the commission had some general authority on corporations law when we were looking at the nonprofit corporations law. We no longer do. There's a narrow little slice of authority having to do with unincorporated associations, but no general authority to reform corporation law as corporation law. So while I thought that that was a sensible extension, it's beyond our authority. So that's an example of where we might, it might be helpful to have extended authority to work in this area. Not that we are thinking we're going to change tax law or something like that, go far afield, but a little bit more room to maneuver might be beneficial. And that's all I have to say about it at this point. I would say that to the chair that Marjorie Murray, who's a regular participant, had raised her hand and then separately emailed me asking for a chance to talk about that, although now I see that she's lowered her hand. So I'm not sure.
Since she went out of her way to email you, Brian, you want to turn on her mic? And there she goes.
Yeah,
she's back on.
she's back on. So
The chair recognizes Marjorie.
and you should be able to talk now if you unmute your microphone. There you go. Hello? Not hearing you. Your microphone's not muted, but I'm not hearing you. Yeah, I'm not sure what's wrong there.
Well, Marjorie, since you emailed Brian before, if you want to make a comment in an email, perhaps, Brian, you can convey that.
And I will say I've had phone conversations with Marjorie about this topic. And I'm going to leave her mic open in case she figures out the technical problem. But I've had email exchanges and phone calls with her about this, and she was generally supportive of the idea of the commission doing work more broadly. And, you know, in particular, she liked the homeowner association teleconference option and thought that it should perhaps be available irrespective of whether there's an emergency. I think there's, you know, that's an argument and it might be correct. I don't think that would be the kind of thing we would do in this context. I don't think we would use this as a platform for just making sensible reforms generally. I think our focus would be on things that make sense as emergency responses to emergencies. But speaking broadly, my recollection was she was supportive. So commissioners, like I said, I'll leave Marjorie's mic open so she can speak if she can solve whatever the problem is. But in the meantime, what do you think about requesting an expansion of authority? I should say there's a vehicle for this. We currently have ACR 173, which is our resolution of authority, pending in Assembly Appropriations. It was just approved by Assembly Judiciary a short time ago, and it's unfortunate that we didn't have this conversation before that hearing, because then we could have had their thoughts on whether and how to address this. But I do think that we could at least request that the legislature modify our resolution if we want to ask for broadened authority.
Commissioner Boyer-Vine.
So maybe I'm biased here because I'd like to see what my study committee produces in terms of whether it's recommending a uniform drafting committee, drafting committee on a uniform law. So, I mean, I don't mind the idea of the commission looking for broader authority within a narrow context. So the idea that you would do the, you know, Sterling Davis groups and give them teleconferencing authority in emergency makes sense to me than to look for maybe broader authority for corporations. So when you ask the question about, you know, are we interested in broader authority, I guess my answer is yes, in a limited scope. Mm-hmm. And I wouldn't say you go for broader authority for everything you could do with respect to law reform in a pandemic, but we're a little more targeted in what we decide we want to approach the legislature with. And you got a second house, Brian, so you can get it through the Senate.
I mean, that makes sense to me. It might be tricky to draft it, but I think we could do it. The other problem with unlimited emergency response authority is we might get deluged with suggestions that are clearly outside of our expertise.
Commissioner Rubin.
I am a little concerned that I think the question posed was, how are we going to respond to the pandemic, which is occurring right now? And we strayed a little bit in these answers from that particular question. At least in my opinion, we may have done that. I fully understand the need to want to not expand our authority and our scope of our authority beyond a point where it's unfeasible. I understand that. By the same token, I think it's important to understand that the pandemic is an extraordinary situation, which I think it requires us to look at possibilities that we haven't previously thought about. Otherwise, we wouldn't have even raised the subject. So with that having said, I'll offer a couple of suggestions of areas that are not part of our immediate reform efforts or study efforts, but which I think have consequences that are long lasting. And this commission works on legislation all the time that has consequences, or it should be doing that, that are long lasting. So for example, I think of the fact that we should look for at the situation of wrongful termination suits for employees who refuse to work because of unsafe conditions. This has become a very important matter right now. And it's going to continue with the unemployment rates rising dramatically, and will continue to do so in California. And I think there are going to be a lot of suggestions made about how to proceed in that situation. I'm guessing there'll be a lot of suits brought for wrongful terminations in the months to come, as more employees are impacted by the current pandemic. So the question I would pose to the commission is, do we want to look at that as a situation where we want to make some potential changes? And while I still have the mic, I'll bring up just a couple of other ideas and then throw them open, if you will, Mr. Chairman, to other discussion. Nursing homes are a major epicenter of infections at this time, and for very important reasons. They are very obviously implicated in the fact that older people are in them, and the population in this state is becoming older and will get much older in the years to come. It seems to me that there should be a discussion about the immunity for liability for nursing homes, because there are people who are incredibly important to the recovery system and we're putting in place, and many of them are in nursing homes today, for which there are not a sufficient number, frankly, to accommodate those in the elderly population who are becoming ill. So it occurs to me that that's a pandemic, specifically pandemic-related situation that we would be and should be potentially looking at. I would indicate, perhaps suggest one other thing, which comes into our purview, and that would be expanding worker compensation benefits, which we have to determine, or it's going to have to be determined, whether they should be retroactive or not for essential workers. And that again is going to probably raise issues, if they're not already being raised, which I think we're going to be looking at and lawyers will be looking at. So those are three examples in my mind, and I have a number of others that came to my mind when I was starting to give my thoughts to these ideas. Anyway, I'll leave it at that, but I wanted to make mention of those areas.
Commissioner Boyer-Vine.
I just wanted to mention, with respect to the wrongful termination area, I believe there's at least one, if not two bills going through the process right now to deal with, wrongful maybe expanding FEHA to include discrimination based on COVID-19. I don't know much about the nursing homes. I do know the governor has done some work by executive order in the area of workers' compensation and liability, COVID-related illness for a worker who goes back to work, because it's kind of a hard situation. And so I think while that's just temporary through an executive order, it certainly is an area that perhaps is worth looking at, because he saw the need to waive certain laws in the workers' comp area. I know nothing about nursing homes other than to say my experience on this commission, when you start getting into the immunities issues, you get a lot more pushback. That doesn't mean you don't do the work, but I think you'll certainly see as a new commissioner where the consumer lawyers are and others in the framework with respect to those types of issues.
Commissioner McAllister.
Okay, let me unmute myself. I was thinking along the same lines. There are a lot of things that are going to be challenged as a result of this pandemic. One of them being, I anticipate, honestly, a number of OSHA cases coming out of this. And I don't know if that's beyond our purview as far as Cal OSHA law, but it might be something that is triggered by some of these parallel issues that we're talking about with respect to, let's say, nursing homes or wrongful termination. And that would be an area of study that I think the commission, depending on the scope, of course, in our relation, can study it, that might be applicable and hopefully helpful in terms of deciding how to move forward on some of these issues.
Anyone else? No, okay, go ahead, Brian. Oh, I'm sorry, Commissioner no, Crystal Bryan.
Okay, thanks. I think a way to approach this might be that we look at, I think it was maybe in January, I'm not sure, Brian, when we spoke about what authorities that we did have and whether to let them go. And I think that it may be easier or just more expedient to seek authority to extend authority that we've had in the past for things that have been within our purview or studies. And then from there, we can address any issues that might clash with subject matters that we've dealt with. Because otherwise, I think that to just try to identify all the different issues that may be triggered by the pandemic, I think it would be overwhelming, and I just don't think that we have the resources or the expertise. And I do believe you've got the Insurance Commission, you've got federal OSHA, you have so many different people right now that are trying to weigh in on how to make sure that this situation never happens again. So that just may be a way, and that was my thought, is that I think that we should deal with the things that are within our authority based on past authorities. And then I think, of course, you know, the commissioner brought up a really good reason, or Commissioner Rubin, I'm sorry, that he brought up good ideas with what can we then maybe address on an emergency basis. And even though the torts and estates or the trust and estates bar has already addressed workarounds, I think that the legislation, the fixes that you've proposed, Brian, are excellent. But anyway.
Anyone else? Okay, just to add my 2 cents, I appreciate all the thoughts of all the commissioners. I think historically we've been more focused on procedural matters than substantive matters. So my concern is that a number of these topics raised would require many, many hours of hearings from many, many special interest groups, lobbyists, and concerned stakeholders, and would fall out of our purview. So while I am in favor of expanding our authority, I would think we would lean on our traditional path of being more focused on procedural matters, because at the end of the day, we're here to assist the legislature, not to be legislators ourselves. Brian.
Yeah, I would add a couple of things. One is the suggestion that Commissioner Miller O'Brien made about how to limit a request for expanded authority is one that had occurred to me, which was to somehow tie it to topics that we've studied in the past. So that, that's consistent with the idea of working in our bailiwick, where we would be most effective. The other thing is, there's another concern that I raised early in this discussion was the idea of not duplicating the effort of others and stepping on what they're working on. And the big issues that Commissioner Rubin raised that I think are really important, it's my strong intuition that there are people on both sides of those issues already fully engaged in trying to address them. And I don't know that we would add much to that sort of political process that's going on. The idea I had was of being a little more surgical and addressing things that fall into the gaps that are important, but there's no natural constituency that's going to be pushing for reforms. Doesn't have to be that way, but I think that if we do ask for authority and then step into some of these bigger arenas, I don't know that we're going to have as much to offer as the major players on those issues. That's all I had to say about it.
So Brian, I don't see any specific proposal for us to need to have a vote on. So I guess you'll be taking our discussion right now as being some sort of charge to bring forward a proposal at the next meeting, suggesting the expansion of authority.
Well, that's kind of an interesting point that sort of foreshadows a couple of more issues that are presented in the materials about sort of the speed of our process and the scheduling of our meetings. We're not really an entity that's designed to be nimble. You know, it's more our process to dig deep and take our time. And so if we were to postpone a proposal to expand our authority until the next scheduled meeting, that would be a couple of months. Now that wouldn't necessarily be a problem, but it would mean that in the meantime, we'd just be idle on that.
So would you like a motion and a vote on the concept of the commission approving an expansion of authority or suggesting the expansion of authority?
Yeah, or maybe put a pin in it until we talk later about process and meeting speed and then come back to it.
Okay, well, we come back to it after the meeting schedule discussion then. Anything else, Brian? I think you have a couple more points on this.
Yeah, let me give you an example. And this sort of also there's a whole sort of snarl of issues here for us. And I think that taking a sort of case study, the issue about remote notarization can help us to understand and think about a bunch of these. You know, as I said, my idea originally was to work on things that didn't have natural advocates, that wouldn't get done if we didn't do it. And that's where we would be most effective. And I raised the remote notarization as an example of that, only to learn that there are a bunch of people pushing for that and that there's a bill in the legislature. And so that presents us with a question of, well, is that something we need to work on? If other people who are really invested in this, like Texcom, and individual estate planners are already talking to the Secretary of State, who's a significant player. They already have a bill pending in the legislature. Maybe we don't need to put our shoulder to that particular wheel. And then the other thing that's in the materials for discussion is how strict we want to be with ourselves about not taking a position on things that have been introduced as legislation. We have a provision in our statute that says no employee of the commission and no member appointed by the governor shall, with respect to any proposed legislation concerning matters assigned to the commission for study, advocate the passage or defeat of the legislation by the legislature or the approval or veto of the legislation by the governor. And we've always treated that fairly strictly as a bar on us participating in any way in a proposal that's already before the legislature. I mean, the exception being our own proposals. You know, if we make a recommendation and there's an implementing bill, we work with the legislature to provide background information. But if we're working on something and somebody else introduces a bill that's perhaps different from what we're proposing or considering, we've been pretty gun shy about continuing to work on that topic. And an example from this meeting is the electronic surveillance study that we did. We were pretty far into it when Senator Leno introduced a bill that sort of took over most of the territory that we'd been exploring. And the commission decided to table that study and wait to see what happened to the bill because we didn't want to be running sort of a side channel of policy discussions that might be seen as contrary to or supportive of the work that the legislature was already doing on the topic. So we sat on our hands for a few years waiting for the dust to settle on that rather than be seen as taking a position contrary to this statutory prohibition. So, you know, with respect to the notary proposal, I think personally, I think it's a good idea. That's why I put it in the memo as an example. I was happy to hear that others think it's a good idea and are working on it, but I don't know whether we should therefore just back off completely. I don't know where that leaves me in terms of my outline, but that is an issue that I think we have to talk about, is what our posture is going to be if we learn that others are working on issues that we're also working on.
Any thoughts, commissioners?
Are you there?
Laura O'Brien, yes.
Yeah, I think maybe, Brian, what the commission should, the posture should be that we lend or contribute what work has been done to the stakeholders that are involved in making or promoting or developing certain legislature that might be addressing the same exact issue.
Just informally talk to the like bill author staff.
Yeah, and then because I will say that, you know, just in terms of like private industry, the opinions and the work that the commission does, it's searchable and it always lends a hand. It's always helpful. I always end up bumping into someone who says, you know, I was looking at that study and I don't think that we ever really, you know, appreciate how influential and how helpful the work that the staff does to promote, you know, to develop what we're studying is on other areas that we may never have been, you know, that we've imagined or considered. So I think that the work is not for, you know, it's not done in vain. I think that it's helpful, but I do agree with you that we need to, we want to be an ally, not necessarily promote our own agenda. And that's what should stop us when we become reasonably aware that someone else is working on the same thing.
Not to put anybody on the spot, but I'd be particularly interested in hearing from Commissioner Boyer-Vine, Commissioner Chow, and Commissioner Simpson, if they have thoughts on this issue and how the legislature would see it, or the governor's office.
Any of the three of you?
Yeah,
Go ahead.
Go ahead.
Commissioner Chow.
Oh, yes. I tend to agree. I think that we do have an outstanding bill out there. I think it's SB 1322. I think we don't want to do redundant work. You know, if the legislature or the legislator is currently working on something that may be contrary to the outcome that the commission may come up with, I think that may present a problem. And the other aspect is that the timing of our work compared to that of the legislatures. So since they're not in sync all the time, so by the time the bill passes, then maybe we're still in stage 1 or stage 2. So are we using a lot of resources that we don't need to really devote into doing this? So that's a concern that I may have also. So granted that we do, the commission does a lot of work that the legislature may or may not do, but yet it is a legislative proceeding that's ongoing, and there's proponents and opponents to it. So does the commission want to get ourselves into the back and forth and insert ourselves in the middle of a fight, so to speak? So that's my 2 cents.
Commissioner Boyer-Vine. Commissioner Boyer-Vine?
Yeah, actually, I think Assemblymember Chow said it well. I tend to take a conservative approach, and my office has the same restrictions about not supporting or opposing legislation. And so I wouldn't want the commission to lose its good name because we get ourselves in the middle of some type of disagreement between the sides and we're viewed as taking a position one way or the other.
Any further thoughts? Commissioner Simpson in particular?
I would concur with sort of both Diane and Ed. If the legislature were to ask us about how to think about, take one of Richard's suggestions on wrongful termination. I don't know that area of law, but I assume it's a conflict between employees and employers in that thing. And if the legislature were to ask us, you know, how should we think about this? What are the conflicting issues or interrelationships with other parts of the law, that sort of thing. That seems like it might be our wheelhouse, but I'm be a little uncomfortable sort of jumping in and saying, in this kind of a situation, there should not be any, you know, any categories of termination shouldn't be allowed or something like that. I don't know if that's sort of our wheelhouse to make those sort of policy judgments.
Yeah, I totally agree, Commissioner Simpson. And I was going to make that point and even be more radical or straightforward and say that perhaps we shouldn't delve into anything unless specifically asked by the legislature. And obviously,
Well,
we can prompt the question by raising some things we've thought of and conveying them to Commissioners Chow or Roth, our two legislators who are on the commission. But that we would actually need the moving force to be from the legislature rather than ourselves, because all sorts of chaos can ensue if individual commissioners are pressing for specific topics.
I mean,
Commissioner Simpson?
that would be my general inclination as well. But I mean, one of the things on the, I think in Brian's memo was about sunsets, right? That there may well be laws that are going to sunset that with the legislature in sort of an abbreviated session may not even be focusing on laws are going to go away. Oh my gosh, this law is going to go away, and we didn't even think about or have the time to deal with extending or not extending the sunset. That sort of thing seems like something we could maybe add some value to the legislature. Oh, by the way, did you know these laws are set to go away, and if you don't want them to, you need to take action now. I mean, that sort of thing seems to be one of our wheelhouse.
Then perhaps the charge we could give to our staff is that I'd be even very specifically narrow and say that with the exception of sunsets, we should wait for some sort of instruction or request from the legislature or legislators. But with the one exception of sunsets, that we be conservative. Commissioner McAllister.
Yes, usually when we talk about introducing new topics, I guess I wanted to make the caveat that I believe this is an area of the law that will require some study. I'm not saying that I would not request authorization to expand our scope and immediately delve into that. We do need to be cognizant that we are not legislating and that we need to be very objective and neutral in how we approach all the topics. I know that's going to be, that sort of comes up in relation to if we have competing studies at the same time, that we make sure that either not just from a duplicative nature of work, but also that we are not trying to influence or advocate something, that we just remain the neutral party that we've always been. So I guess that was that. I agree with all the comments that have been made regarding that, and sunset provisions obviously are of paramount importance right now, and we need to address that. I'm fine with if commissioners would be interested in limiting our specifically just to sunset provisions. That's fine with me, and then we'd look for direction from the legislature or from our two legislator committee members if there's something that they would like us to continue or to explore on our own. That was my thought.
Go ahead, Brian.
Yeah, 2 points. One is that I was already contemplating that it might make sense for the staff to make informal contacts with relevant committees and people in the governor's office before we invest significantly in any topic, because I would want to know whether that would be helpful, be seen as something that would be a good use of our time. And especially if it turns out that there's already work in progress and that we would be stepping on it and they wave us off, that would be good to know. So I hadn't been contemplating like limiting our work to items that we were expressly asked to work on, but I had thought that as a practical matter, it would make sense to keep informal contacts open and make sure that what we're doing is useful. The other point I was going to make is that Marjorie and I have been corresponding by email, and she's now on a phone call. And so if be a good time to hear from her, I could try and see if that works.
Go ahead and try that.
All right, here we go. Where is it? Oh, Marjorie, are you there?
Yes, I'm here, and I apologize for not being advanced technologically. I don't know what the issue was, but in any event, I wanted to make a comment about an earlier topic, and if it's still appropriate, I wanted to address the issue of, the framework, so to speak, of your memo, Brian, and the earlier discussion about should the commission be looking at emergency measures, or should the commission be taking a more broader framework? I really just wanted to make one comment that although we're thinking of the pandemic as something temporary and that it's going to be over, I personally am not looking at it that way. It seems to me that the state of California is in a perpetual emergency of one sort or another. In other words, for the commission to be talking about emergency measures may be looking at the issues through not the wrong, but too small a lens. That if it's not a pandemic, that it's wildfires, that it's floods, that it's, we're in the grip of not only health issues, but also climate change. And so whatever issues are taken up should be viewed through this larger lens of a changed environment in which we need to examine things quite differently. It's not an emergency that's going to be over in August or even in January, but it's a more global picture with quite changed components. And I hope I haven't derailed the conversation here at all.
No, thank you very much, Marjorie.
And as a matter of fact, the commission does know or may remember that the topic of interest to our Center for Homeowner Association Law is, of course, the common interest development and those issues which impact governance and public policy. So we were paying particular attention, and this is why I got in touch with Brian about the board meetings in an emergency environment. But we're looking at a bigger picture than just that. Thank you.
Commissioner Rubin, I think you had your hand up.
I was going to simply indicate that I appreciated the comments Marjorie just made, that this emergency will not be over until, I'm going to sound like Yogi Berra, it won't be over until it's over. And the state of California does have emergencies that are long lasting in many, many areas. And presumably we have an interest in wanting to bring them to a conclusion, to a termination, if we can possibly do so. That said, the discussion as I've been listening to it, and I'm not opposed to the discussion at all. It's very helpful for me as a new commissioner to hear what you're saying. I get the impression we're spending a lot of the time reasserting the parameters that we've already established for this commission, which don't need a lot of attention. The question was posed, should we expand our authority? I'm not hearing very much so far that tells me that we are interested in doing very much expansion of it, which may be exactly the right thing to do and not expand it. But I think that we've spent a good deal of time here kind of reaffirming the fact that we take a more narrow, conservative, non-particularly proactive approach to what we do and how we do it. And that may be fine. If that's the history of this commission's approach to things, then I accept that fact. I think, though, that this pandemic has been a wake-up call for society, for California, for everyone who governs in it, at every level, state, local, county, everywhere. And we're looking for ways now to prevent this incredible atrocity from occurring again. Wildfires have been mentioned. That's another atrocity. Climate change, it's going to continue. There's no timetable on when these emergencies are going to conclude. So in my opinion, if the commission is interested in making a contribution without legislating, it is appropriate for us to look at areas where we can be robust in suggesting legislative initiatives that others may take a look at, even if in the end they don't follow them. So I prefer the idea that we provide guidance in some of these areas. And if it is the determination of the legislature and the governor not to want to proceed, that's obviously their prerogative. But I don't think we should be duty bound to the idea that we have to simply confine ourselves to issues that have been already looked at in the past, if they've not, when we're looking at the fact that there are emergencies that are raising issues which are new. And that's what this pandemic has done. And it won't be the last pandemic in our history. We hope to God it's not going to be something that recurs. But as it's going on, we're hearing from every source in this state that it is not something that's going to end very quickly. And the measures that are going to be enforced and put in place, and which are being talked about now in the legislature, are in fact important ones. And I think our advice to them within the resources we have are useful and valuable. So I may be only a soloist in this process of what we're talking about, but those are some of my feelings. Thank you for letting me expound a little bit, Chairman.
Brian, perhaps if I could try to summarize or make a proposal. Clearly, most or all of the commission is in favor of some sort of expansion of our authority. The question is as to how much and in what circumstances. And there's a spectrum of views on that. What I was proposing, just to clarify, was not that we need an express charge from the legislature, we don't need a resolution, but I would be hesitant to open up any area of study which wasn't specifically backed by one legislator, at least, as being important work for us to do. And of course, we can prompt that. We can, through our channels and through our two members of the commission who are in the legislature, say that, hey, we've been thinking about this, and we need one of you guys to tell us to go ahead to explore it. And with the only exception of being the sunset measures, which, as you've explained, Brian, are self-explanatory, that we probably should go ahead and take a lead in some of those issues. How does that sound, Brian? And are you looking for a motion and a vote today on this topic? Executive Director Brian Hebert.
Thank you. I think it sounds sensible what you've outlined. I think it maybe could be a little broader than requiring the approval of a specific legislator. I would see value in talking to the staff and committees. So for example, this proposal about teleconferencing in homeowner associations. I've got contacts in both housing committees who've worked with us on CID issues before. And I think we'd get a pretty good read from them about whether this was something that they'd be interested in. And they might even be running committee bills to aggregate sort of COVID response measures this year. So I like the idea of having the legislature vet what we're proposing to work on. I would be a little reluctant to make it overly formal just because it might be binding in ways we don't anticipate in advance.
Okay, again, Brian, do you want us to propose a motion and a vote today on this topic?
On that topic, I think yes. I mean, the related topic, which is important, I don't know if we're ready for it, which would be asking for an actual expansion of our authority in the resolution that's before the legislature this year. There was a specific proposal from Commissioner Miller O'Brien with the idea of asking for an expansion to do emergency related work on topics that the commission has been authorized to study in the past. And then there were also suggestions of going substantially farther than that and asking for the necessary authority to do things we've never worked on. And
Well, with regard to things in the past, we already have that authority. So
not
there's
if
really
they've
not.
not if
there's-
they've been removed.
Okay. Okay, very good. So do you want to have the motion and the vote after we discuss the meeting schedules, or how would you like to proceed?
Maybe so. Maybe we could do a roundup at the end, and so that way everybody understands sort of the package of issues in connection to each other. And I could recap when we get there.
Okay. Do you have anything
so
else
that's
for
a
this
good-
item then before we go on to the meeting schedule item?
If I
well,
could also, I'm sorry, but because I do think the meeting schedule these topics are, they run in tandem, Victor, because if we were to set aside or bench a topic and not be able to get back to it for months, I think it would be very detrimental to just Californians. If we can help and lend some guidance to current legislation, I think we need to address it. But if we don't have to necessarily defer or make an issue or make a vote, I think, or a motion until after we hear the meeting schedule topic, or vet, just deal with those ideas first.
So,
Brian, are you ready to move on to 2020-21, or is there
no, I think there's
something
a
more?
little bit more I'd like to talk about on the 19.
Okay.
One has to do with our process, and this is related to scheduling. Those of you who are new are not as familiar with how the arc of a project is. Those who've been around longer know very well what that arc is, and it's usually a long one. We usually have an initial period of consideration of relevant issues, presenting staff research and analysis, working through things, getting to where we have a provisional reform proposal. Then we release that as a tentative recommendation to the public for a period of comment that's usually pretty generous, 2, 3, 4 months, depending on nature and scope. And then we have a series of meetings where we consider the comments we received and whether they persuade us to make any changes to our provisional recommendation. And then only at that point do we get to where we actually have a final recommendation. So because we meet every other month, and because of that arc, even the simplest proposal is going to take a year before you're done with it. And that's okay, because the legislature usually takes a year to consider any proposal that we pass along to them. But we've had very simple things, like just a little tweak of the Marketable Title Act or something. What was obvious, but we still ran it through our process and it still took a year. So one of the things that I raise as a possibility in one of these memos or supplements, I think the first supplement, is the possibility of expediting the usual timeline for emergency-related reforms of the type we've been discussing. And we do have in our quiver some practices that we've used to expedite things in the past. Usually when time is short, we have considered the possibility of letting staff do drafting work offline, subject to the approval of the chair. And the commission sort of delegates that authority to the staff to do the drafting and the chair to bless it, that it expresses the commission's decisions and will. We could sort of build on that sort of extraordinary procedural step that we sometimes take and make it routine in these emergency related reform efforts. So for example, if you decide at a particular meeting, yes, proceed with legislation to fix sunset dates, I could, after that decision is made at a meeting, I could draft up what would be the equivalent of a tentative recommendation and release it for public comment. And then at the next meeting, we could consider the comment. And if the commission is content with the policy and the general contours of it, they could approve it subject to any final drafting done by staff and approved by the chair. So that compresses the turnaround time to 2 meetings. you know, and we usually have a span of a couple of months between meetings. So that might mean that we could get from 0 to a final recommendation in 2 to 3 months. And if what we're looking for is the possibility of handing something off to the legislature mid-session for amendment into a bill as an urgency measure or for enactment in the same year, it might make sense for us to shoot for a quicker, shorter arc rather than just assuming, well, everything takes a year, we'll hand legislation over in 2021. Something like the fixing sunset dates, if the legislature is interested in doing that, that can't wait till 2021. I see a hand, Victor.
I'm sorry, Commissioner Borivine.
Well, I think, and maybe Commissioner Chow knows this if he's still on. I got the sense, Brian, with the very expedited legislative calendar and the limited number of people who are coming into the building and doing work, that they have set their agenda for the year. Now, the sunset issue is really important because, as Rick knows, when you sunset something that has offices, you're not going to be able to bring it back online through an urgency clause. So you run into some trouble.
Yeah.
But I just want you to be aware, if you're thinking about something this year, I get a real sense from my colleagues in the leadership that they've set their agendas.
Yeah, okay. I mean, with respect to the sunset, I know this came up because we confronted in our bill on revocable transfer on death deeds. You know, we just did our study, we recommend extension, sunset it in 21. And so if we don't do anything, the bill dies, or the statute, the existing statute. So that came up in that bill. And as mentioned in the legislative program memo, Senator Roth has trimmed his bill implementing our recommendation back so that it does nothing but address that issue. And that's being heard in the Senate tomorrow. So we're covered. But I know that he's also been having discussions, and I don't know to what extent I'm allowed to speak freely about it, but he's been having discussions about the possibility of using other vehicles to achieve the same purpose. And so if there's already a marker down for his fix, that could perhaps be used to address these other issues. But I think it's important what you're saying, that like the thing about HOA teleconference meetings, we might say, get a response that, yeah, that's a good idea, but we're already full. We're at capacity. So with all of that in mind, I mean, maybe if that's correct, then there's less of an issue that would justify deviating from our normal, more deliberate pacing. So I think I would just leave it up to the commission at this point to see what appetite there is for changing our trajectory and speed on these particular kinds of studies.
Commissioners? Well, with that dose of reality, Commissioner Borivine, it seems to me that maybe perhaps to move things forward at this meeting, we would just have a motion and a vote to expand authority with regard to sunsets, Brian, and nothing else for the time being. Why tie our hands on that issue, since there seems to be widespread agreement that's needed, and I don't think there'd be much opposition to that request for expansion of authority.
If I can add, the meeting, if we expand or change our process to meet more often or more frequently, then I think the process could be impacted. So can we deal with that topic before we vote on how to expand or limit or, I don't know, restrict our authority?
I think that makes sense. And I think that's what Victor had suggested is that, and that what I suggested after you raised this issue before, which is I think it makes sense that we vote the whole bundle. And so we talk out that scheduling issue too. Does everyone want to talk briefly about it right now?
Okay, we'll move to Memorandum 2020-21 about meeting schedules.
Yeah. So the impetus for the discussion item in that memo was my experience with Zoom, that it has diminishing returns over time. People get worn out by the process. And so what I wanted to raise was the possibility of changing our meeting schedule practice to lead to shorter meetings. And there were two ideas that I floated. One was more frequent meetings that are shorter. So for example, instead of going every 2 months, we'd go every month, but we'd do it for 3-4 hours in the morning and then be done. The other possibility is taking our currently scheduled meetings, which are every other month, and converting them into half-day meeting, two half-day meetings back to back. That's what the committee did. We had a morning session on a Thursday and then a morning session on a Friday, I think, if I'm remembering right, but 3 or 4 hours each, 2 days in a row. And so the overall duration was broken up, but we stuck to sort of the arc that we had originally projected in terms of the frequency of the meetings. Now they're also actually, based on the experience with the Zoom meeting, they're now trying to schedule interim meetings as well as purely informational presentation meetings. So you still have every other month a big deliberative meeting with decision making, but in the month interval between those, they're going to have just presenters who share information and answer questions. So it occurred to me that you may want to have shorter meetings, and if so, then we ought to think about how to do it. And I think that Commissioner Miller O'Brien is right that this is related to what we've been talking about, because if we went to monthly meetings, then we could put the stuff that needs to go fast on the agenda for every meeting, and it would go at twice the rate of our normal process. So one of the issues that you should think about is whether you want to change the timing and duration of the meetings. Does anyone want to discuss that?
Commissioner Boyer-Vine?
You're only talking, I'm sorry, I don't know where it is in my binder to look at the memo. Are you only talking about during this pandemic, or are you talking about on a going forward basis? We would use Zoom more often and do it monthly.
Well, I was only intending to talk about during the stay at home.
Okay.
Because I don't know, once the pandemic is over, whether the Open Meeting Act would permit this. Once the emergency powers expire, this may go back to being unlawful.
Good, yeah, good point. You're right.
Makes me feel like a rebel.
Or our vote on that can incorporate that concept that for only during the times that the pandemic situation is involved, we would have this alternate schedule.
Yeah,
if I could propose something, Brian, I think it's a good idea for us to meet monthly for a shorter time. But if I could also propose, since we have to first expand our authority in some ways to see what we're going to fill that calendar with, that perhaps we meet 2 weeks from now just on that topic, if necessary, and then go from monthly from then on. What do you think of that, Brian?
I think 2 weeks is the shortest turnaround we could do in compliance with the Open Meeting Act, because you have to give a couple of weeks notice agenda prior to a meeting date. So 2 weeks is legally permissible. And you're saying 2 weeks to come back solely to consider and discuss the possibility of asking for expanded authority and how we would do that.
Well, assuming you don't feel comfortable of us doing that today, I mean, do we need additional feedback from stakeholders, or how do you view that? When do you perceive the vote on expanding authority should take place?
Well, I think it really depends on the commission's substantive preference. If the commission substantively decided to request an expansion to include emergency reforms related to any topic that we've studied in the past, you could vote on that today. That would be easy to draft. And I could talk to the legislature about it and see whether they have appetite for that without further deliberation. But if the commission wants to consider a broader expansion request, then I think you would need to actually talk through, like, what are the contours of that going to be? What are we going to put any kinds of limitations on it, et cetera? And I don't think that you'd be ready to vote on that today, because I think that it's just depends on too much that we haven't yet aired.
Commissioner McAllister.
I would be absolutely in favor of us doing monthly meetings. I think that shorter meeting monthly and continuing to move items on the agenda would be really productive. It is difficult to do this via, but certainly be proactive and get things through. I would be in favor of the analysis that Brian just presented in terms of, I think we should vote today on having a narrow construction. There are too many parameters and too many things that are uncertain at this point without reaching out and trying to figure out if we wanted to do any further expansion of authority. So in order to continue our work and address the items that we already have on our docket, if we could, I would be approving this narrow expansion to go ahead and move those along and then meet monthly and keep the momentum going while continuing, I think, for Brian to reach out and see if there's any appetite or any desire on the part of the legislature to have us examine any other topics.
Commissioner Simpson.
Yeah, I concur with Jane, I think. The only question I had about, and I'm fine with shorter, more frequent meetings, that particularly if there's something we want to accelerate in terms of our process. My only question related to that is, I want to be conscious, is that going to put additional pressure on the staff? And does that mean that they're going to be, we're going to have to do a hierarchy of, like, some of the other studies that are ongoing are going to have to be deferred, delayed, while we have staff focused on these more accelerated processes? I just don't know whether that is something we need to at least keep in mind.
I think it's workable. I think what it would mean if we went to monthly meetings is that some of the projects we work on, where we're just sort of grinding through a series of decision points, we can just do less work, take a smaller bite. Where we can't do that because it's not that granular, we could schedule it for every other monthly meeting and it would be no different than it is right now. You just wouldn't see a particular study on your agenda for a month. It would come back again later. So I think we could make it work.
Okay.
So do I hear that we have sort of shaping up a proposal, and the proposal would be that we vote today on a narrow request for expansion of authority, that we vote today for monthly meetings from this point forward. Is that correct, Brian?
I have heard that as a proposal, yeah.
Any objection to those two sort of points? Okay, Marjorie in the audience has her hand raised. So why don't we turn to her? Marjorie, are you on the phone again?
Yeah, she's not on the phone. She's on her computer. I've seen that hand raised and I assumed it was just a holdover from when she was on her computer. She's free to speak right now, completely open channel. And so I think we
okay, her phone is slashed out on my panel. Do you have to release her phone in case she's trying to say something?
Oh, I see what you're saying. Okay, let me, thank you. Marjorie, are you there?
No, I am, Brian, but I'm just listening. I didn't have a hand raised. I think that's a holdover from my previous efforts. Thank you.
Yeah, thank you.
So Brian, it seems there's no objection to what I just said. Do you need a motion and a vote on those two concepts? One, that we authorize the commission today to seek a narrow expansion of authority only during this pandemic period. And secondly, that we move to monthly meetings.
The monthly meeting is something that I don't think we'd need a formal vote on, but a request to modify our statutory authority, I think that requires a vote. So why don't you just make it a combined motion and do a roll call?
Okay, I'll go ahead and move for that then. I make a motion that we will seek a narrow expansion of our authority during this pandemic period, and also seek to move our meetings to a monthly schedule. Do I have a second on that?
Second.
Any discussion? Okay, all those in favor, say aye and raise your hand.
Aye.
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 All those opposed now.
No.
Commissioner Rubin, any abstentions? Okay, the motion is carried, and so we're
And
done
I'll
with
note
that.
that Commissioner Chow does not seem to be present. I'm going to record him as not present.
Okay.
Okay, so that's helpful. And so I think that with that change and the discussion that we've had, I didn't hear appetite for sort of expediting our study process beyond the scheduling change. I think it might be helpful. It sounds like the sunsetting study is one you want me to move forward with right away, and I'll speak informally with the legislature and see whether there's a vehicle for that. With respect to the other studies that were proposed in the memorandum, CID remote meetings, remote notarization, and remote witnessing of wills and other documents that require witnessing. Do you want me to communicate informally with the judiciary committees or with our legislative members and see whether that's something they would like us to look at before taking efforts in those directions? In particular, let me separate out notarization. Let's just talk about CID remote meetings and remote witnessing of estate planning documents. So I see a thumb up. Does anybody not want us to do anything on that? Okay, so I'll talk informally with the legislative contacts I have about those. I think notarization is in a different category because there's a pending bill, and it sounded like the discussion we had about coordination with other reform efforts, that there was a pretty strong trend towards a conservative approach of backing off if there's a legislation in the legislature on the same issue. Does anyone feel strongly different about that? They would like us to proceed, notwithstanding the fact that that's out there. Okay, so we will not pursue that one. Would anyone have an objection to me talking informally to the author's staff with some personal thoughts I have about the issues? Do you feel like that would be crossing the line? Okay, I'll do that. So there's one other item that's covered by this Memorandum 2019 that's addressed in the second supplement, which has to do with our work on Fish and Game Code recodification. Commissioners who weren't around for it, we had the pleasure of doing a complete proposed recodification of the Fish and Game Code. And it's out as a tentative recommendation, a massive document. And it's being reviewed by the Fish and Game Commission and the Department of Fish and Wildlife. And, sorry, they are going to be reviewing it and providing us with comment. Now, previously, they had asked that we restructure our comment period to accommodate their workload problems that they were having. This was pre-COVID, and we accommodated them. So that what we did was we split the comment period into two periods, with the first period running through July 1 of this year. And during that period, they would just be looking at comments, providing comment on notes that we raise in the draft. So sort of sticking points. And I think with the idea that those notes raise issues that could be addressed in the existing code without recodifying. And so they would vet those first. And to the extent that they agree that things should be changed, we could work up legislation to change it in the existing code. And then it would be another year before there'd be comment on whether they like the idea of recodifying their code entirely, and they'd give us comment on that. And then we'd have to, deal with whatever comes from that discussion. We've since received a letter, which is attached to, I think, the second supplement from the executive director of the Fish and Game Commission, asking for a 90-day extension to the first comment period. And strikes me as completely understandable and reasonable that agencies that have frontline responsibilities like Fish and Game Commission, they've got law enforcement, they've got regulatory work that they do, that their attorneys have bigger fish to fry, so to speak, than commenting on technical notes we've submitted to them through our process. And so as a threshold, it would be my recommendation that we grant the request and extend the deadline. Beyond that threshold, I kind of suspect that they're being optimistic in thinking that their situation will be improved in 3 months, such that they can get back to this technical work. So it won't surprise me if we hear from them again asking for a second extension. And so it occurred to me that we might preempt that and just do an extension longer than 3 months. So up to you, but it's certainly not a priority for us either. We don't want that work to go stale. We'd rather act on it sooner rather than later. But it's to the extent that we're taking on new work to deal with the emergency, it would be an additional burden for us to go back to analyzing and digesting and responding to whatever commentary they give us. So two-part suggestion from staff. One part is give them an extension, and the second part is consider how long it should be and whether it should be longer than 90 days.
Brian, how about a motion for 120 days, 180 days, or 120?
And the other thing is, I think whatever change we make to the first deadline, it makes sense to make the parallel change to the second deadline.
Would 180 days, 6 months be too long?
I don't think so.
Yeah, given everything else going on in the state, I don't think anyone's focused on that topic for now.
Yeah.
So unless there's any objection, do you need a motion and a vote on that, Brian, for a 6-month extension?
Of both phase 1 and phase 2 comment.
Yes.
I don't think we need a formal vote as long as there's people have a chance to vote no or abstain.
Yeah.
Okay,
so we're not going to have a roll call vote, but how does that strike the commissioners that we extend both the deadlines on the phase 1 and the phase 2 comment period by 6 months? Okay. Are we a majority there, Brian? If not unanimous?
Yeah, I didn't. Any abstentions or no votes? Okay, thank you. So I think that wraps up the pandemic discussion and the meeting schedule discussion. Do we want to turn to the legislative program?
Can you complete that in 10 minutes?
Yes.
Let's do it. And then we'll
Okay.
go to a lunch break.
I mean, it's basically an informational report to catch you up on where things stand with our legislation that's pending. The big disappointment, but not surprise, was that Assemblymember Chow suggested withdrawing the 2 bills that he had authored for us to implement our recodification of the California Public Records Act. There was opposition from a fairly broad coalition of public entities. And ordinarily when we do this kind of work, we expect to get pushback from public entities on the transitional costs. We're going to have to rewrite our materials. We're going to have to learn new section numbers. This is going to be hard, and we're going to have to task attorneys to it, and blah, blah. And I don't mean blah, blah dismissively. I mean, it's common. It's very common objection. It's a legitimate objection. We do what we can to mitigate it. In this environment, those arguments have substantially more weight. You know, if you're talking about local government entities struggling with their budgets and their responsibilities and how to keep their people safe, they don't want to have attorneys working on redrafting their memos and their practices manuals and that kind of thing. So it was my sense that with that opposition grounded in those terms as it was expressly, that it would be reasonable for us to pull it. And it would be unreasonable, sort of palpably unreasonable, if we insisted on pushing ahead. And I talked to the chair and he had a similar take. I think that was Mr. Chow's disposition. So, you know, without objection, we assented to his preference to withdraw the bills, with the understanding that if this all clears up before he's termed out, that he would reauthor for us. So unfortunate, but, you know, completely understandable. We have the bill on trial court restructuring that Mr. Mainshin's carrying for us. It was approved by Assembly Judiciary before the stay-at-home order, and it's in appropriations now and has not been moving. We don't know what the prospects are for that, whether that's something that's so uncontroversial that the legislature will continue to pass it along on consent, or whether, you know, it somehow flares up in a way that makes it too much of a nuisance for its relatively technical value. I think that's out of our hands. But as of now, it's still live. It just hasn't moved recently. As I mentioned, the revocable transfer on death deed bill, Senator Roth amended that to gut it, except for the sunset, 1-year sunset extension. And I think that's sensible. It's essential that we not let the thing sunset, but all the other work that's related to it would be unreasonable burden on the legislature right now, I think, because there was likely to be opposition from Land Title Association, and there would be a lot of wrangling involved in working on that bill. And I think it makes sense that Senator Roth has higher priorities right now. So effectively withdrawn, except for the technical fix on the sunset. And then ACR 173 is our resolution of authority. Mr. Gallagher's carrying that for us. It was approved on consent about a week and a half ago in Assembly Judiciary, and their recommendation was refer to appropriations with a recommendation of consent. So similar to the trial court restructuring bill, I have the expectation that might just continue to perk along on consent, and that might be easy enough for the legislature that they don't need to kick it out. But things could change, or I could be surprised. And that is the vehicle I was discussing in the last item, that if we do decide to request, and sorry, I don't remember what the decision was. It's in my notes. If we decide to request additional authority, that's where we would do it. We would talk to Mr. Gallagher, and then we'd also make sure that, you know, I'm sure would talk to the Assembly Judiciary Committee so they don't feel like we are sandbagging them, and then see where we go from there. So like I said, information only, no action required. Does anyone have any questions? Okay. Victor, did you want to take a lunch break? Okay, so here's what I propose. Everyone turn off your cameras. We were talking about a 30-minute break, so we come back at reconvene around 12:30. Turn off your cameras. I am going to start sharing a little intermission